pledge allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Meeting is being recorded. Roll call. Thomas here. Moyer here. Range here. Secretary here. And Jeff Sliss here.
Hello, everybody. I wanted to, for those of you who don't know me, my name is Jeff Rockman. My law firm is the solicitor for the Township. And before we begin the meeting, I wanted to talk to you. I think probably most, if not all of you, were here on Sunday, March 1st, and saw the events. On the assumption that you may not have understood fully what was going on, I wanted to inform you. First and foremost, the Township, by ending the meeting, did not sacrifice its legal position in the slightest. Notwithstanding the cheering by the 31 interested property owners at the end of the meeting, there's absolutely no legal detriment whatsoever to the Township. This case was always, even if the full hearing was held, this case was always going to go to the Luzerne County Court of Common Pleas, and whoever loses there, it will be on appeal. You can be assured of that, to the Commonwealth Court of Pennsylvania. This is the very, very beginning of a long fight that will take, by my best guess, about at least 4 years to resolve fully, okay, after all appeals are exhausted. Now let me get into the reason why we ended the meeting. First of all, I vigorously dispute Attorney Karpovich's statement that we did not comply with advertising requirements. But he raised it, and we were faced with a choice. Do we want to spend thousands of dollars in legal fees conducting a 2 or 3 day hearing? Or do we want to just terminate the meeting on the assumption that there is a very slight chance that the Court of Common Pleas would say, yeah, you didn't comply with the advertising requirements, and we're just going to void any decision that was taken by the supervisors. So we didn't want to waste thousands of dollars of township money in conducting the hearing on a case which was always going to end up in the Luzerne County Court of Common Pleas. So we ended the meeting. We did not vote to deny the curative amendment. That happened by operation of law under the municipality's planning code. You have 60 days to respond to a curative amendment filed by a landowner. If you do not respond within 60 days, the curative amendment is deemed automatically to be denied. So we did not deny the curative amendment because, again, slight chance that had we denied it formally, there's a slight chance that the advertising issue would have been recognized by the Court of Common Pleas and would have reversed the denial. What we did was we ended the meeting. The denial of the curative amendment occurred by operation of law. This past Sunday was the 60th day from the date that the curative amendment was filed. So it's denied. The next step is for Attorney Karpovich and his clients to file an appeal before the Court of Common Pleas of Luzerne County. And there I can assure you we will vigorously prosecute the Township's position. Vigorously. We believe that the curative amendment is defective in many respects, and we'll let a judge decide. The judge will allow depositions, will allow expert opinions, we will have our depositions, we will have our experts, and we will go to bat vigorously. Okay? I would implore you, we have public comment on agenda items to begin with. And at the end of the meeting, we will take public comment on anything that you people, you guys, you gals would like to talk about. I beg of you, do not engage in a question and answer session with the supervisors. This matter is now in litigation. We cannot answer questions. If you want to direct any questions to me, I'll do my darndest to answer them. As long as I'm not divulging any attorney-client confidences, I will do my best to answer any and all questions. Okay? Let's begin the meeting.
Motion on the agenda?
I make a motion to amend the agenda to include the appointment of Richard Jensen to the zoning hearing board due to the resignation of Wendy Landis.
I'll second it.
All in favor?
Aye.
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 Any public comment on the item that has just been added to the agenda?
Could you please repeat that? Who is?
Yeah, I'm really here about it. There you
I make a motion to amend the agenda to include the appointment of Richard Jensen to the zoning hearing board due to the resignation of Wendy Landis.
go. I second it.
All in favor?
Aye.
Would anyone like to offer public comment to the newly added item to the agenda? Hearing none, you can go ahead. You can go ahead and vote on the added item.
Comments from the floor, public comments on the agenda items only. You made a motion.
I make a motion to approve the newly added item.
I second it.
All in favor?
Aye.
Dennis, please post an amended agenda by the end of the day tomorrow.
Okay.
Or you post it on the door, make sure that there's an amended agenda posted.
Now we can cover public comments from the floor. Comments from the floor now. Comments from the floor, public comments on agenda items only.
Could you use the microphone, Dave?
Comments from the floor, public comments on the agenda items only. How does that sound?
Is it on now? Wendy Landis, 394 Kingsbury Road. I'm going to ask that Lester Markle speak for me, please.
You know, I want to reiterate on what our solicitor just talked about. Now,
If I could interrupt you, the ordinance, the data center ordinance is not on the agenda. I welcome you to offer
Right, no,
public
this is-
comment at the end.
right.
But this is public comment on agenda items only.
All right, this is what you just discussed at the meeting tonight. So this is public.
This is-
So I want to go over.
I'm inviting you to make the public comment. I'm not trying to say you can't make public comment. But if it's with regards to the data center ordinance, please make it at the end of the meeting, not now.
Okay.
The data center ordinance is not on the agenda. That's all I'm
This
saying.
pertains to the county code that you just described, that you were wrong on it. So are you willing to let me talk?
Absolutely. At the conclusion of business, at the end of the agenda, you can feel free to tell me how wrong I am.
All right, well, we're starting off on the wrong foot already.
Not trying to, just asking you to comply with it. Very simple.
You just talked about it.
It's not an agenda item.
All right. Then you talked about it, and it's not on the agenda.
It's not an agenda item.
I'll do it at the end of the meeting.
Okay, thank you.
Anybody else? We're moving right along. Okay. Motion accepting
minutes of the last meeting.
I'll make that motion.
I'll second.
All in favor?
Aye.
Aye. Motion to accept the cash report attached to the minutes.
I'll make the motion to accept the cash report attached to the minutes.
I'll second it.
All in favor?
Aye.
Aye.
Aye. Motion to pay all bills as presented.
I'll make that motion.
I'll second the motion.
All in favor?
Aye.
Aye.
Aye. Okay, reports, road report.
We've been doing winter maintenance and maintenance on our equipment for spring, when it ever gets here.
Okay. Planning commission?
Planning Commission, we met at the Township Building down over the hill, February the 17th, 2026. Hollenback Township, the board was all there. Daniel Jensen, Daniel Derange, Mike Reinheimer, Harold Reinheimer, and Ralph Winterstein, all were present. Minutes of the previous meeting was read and approved, all were in favor by motion. No old business at the meeting to attend to. New business, we had nothing there submitted that night, so there's no new business. There's, of course, the talk of the town for a while, but that's not part of anything submitted. There was a motion to adjourn. All those in favor? Our next meeting will be March 17th. Now that we need to decide, are we having it up here or are we having it down there?
It's up to you.
The whole crowd want to come to the meeting? There's nothing submitted, so there won't be anything.
It should always be at a place everyone can come to, so yes, it should be in this room.
That's,
You can just do them up there.
you don't have it up here?
The
Okay.
chairs are up there, we'll just do it up there.
Our next meeting, March 17th, here, 7 o'clock, right?
Yeah.
That's all I got.
Okay. Sewage.
Got an update from Briar. We had 2 final inspections he performed, one on Hobby Road, one on Council Cup Road, and he has 2 other applications in progress, one on East County Road and one on Ridge Road.
Zoning?
Nothing for everyone to figure out.
Nothing. Fire chief.
One call to the fire company for the month of February.
Thank you. EMA?
No report.
No report? Okay. Now, next supervisor's monthly meeting will be held on Tuesday, April 7th at 7 p.m. Supervisors held an executive session with the solicitor on February 13th, February 19th, February 20th, February 26th, and February 27th. And we also had our March 1st meeting to discuss it. Litigation. PennDOT will be doing a traffic count on Council Creek Road between March and November. Correspondence.
I got a request from Light Path for an update on their... I got an update from Light Path Fiber Optic Installation Company. They would like to know if they're going to be able to start on their construction on Old Norwich Highway.
Okay, old business. Review and adopt resolution regarding selection procedures for engineering by consultants to comply with ECMS, executive applicable PennDOT policies and procedure forms.
Policy and procedures, and here's the resolution number 3 of this year. Signatures go on the back.
I make a motion to approve resolution number 2026-3.
I'll second it.
All in favor?
Aye.
Aye. Okay. Any other old business? New business.
No new business? Okay, I guess we'll go to public comment period. Items not on the agenda.
That wasn't too long away, was it?
All right, first I'll give you a little background on my history. I retired from DP&L, that's Susquehanna Plant, for 40 years of service. I retired as a manager up there of the work management process. I wrote procedures, wrote work instructions, I had planners that put the work plan together, and I also had engineers under my control. That they wrote the ordinances and the procedures, not the ordinance, but the procedures and the processes at Susquehanna, and I had to review them and approve them. So what I want to do tonight is just go over the Pennsylvania Municipalities Planning Code associated to this, and the section, did you give them the copies? Yeah, give them the copies. And what I want to do is, I just want the supervisors, I highlighted the parts I'm going to go over, and this will give you something to review and discuss over what happened on Sunday, and what needs to be done moving forward per the county code. I thought it was important, well, Wendy thought it was important that we discuss this. I was going to have her do it, but it's kind of detailed. So the first highlighted section on the first page is section 609.1, procedure for landowner curative amendments. A landowner who desires to challenge the substantive grounds and the validity of a zoning ordinance or map or any provision thereof which prohibits or restricts the use of development of land in which he is interested may submit a curative amendment to the governing body within a written request that is challenge. Remember that word, because challenge is very important in this whole session that's going on. And proposed amendment be heard and decided as provided by 916.1. Remember that number. The governing body shall commence a hearing therein within 60 days. What was Sunday? The 60 days from when they submitted the curative amendment. And the request is provided for 916.1. The curative amendment and challenge shall be referred to the planning agency or agencies as provided in 609, and notice of the hearing thereon shall be given as provided in section 610 and in section 916. Then I go to the next section, which is B, and it talks about the hearing and everything, but I really wanted to go over just the part that I highlighted, because the attorney talked to that and he ended the hearing on Sunday because of him using the 908 section. So 908.1 and .2 and 9 shall not apply. The provisions of section 916.1 shall control. So that was evidence that he used under the next page, if you look, is section 609, is a procedure for municipal curative amendments. That's for the supervisor to do. So the wrong issue was addressed on Sunday, and that upset me a little bit. So then we'll go down to the next line. Now, the supervisors, the part that I have highlighted, may adopt an alternate amendment which will cure the challenge defects. Okay, again, there's the word challenge. Okay? Now, the township, we know, is working on an ordinance to support this. So we go to page 2, because page 2 talks about, the procedure for the municipal curative amendments, which I'm not going to discuss. We'll go down to 610. Section 610, publication, advertisement, and availability of ordinances. So the curative request is not an amendment yet. So we need to understand that. So I'm not even going to read that paragraph because it doesn't really pertain. So let's go back to the last page. 916, the section number 7. If the governing body or the zoning board, as the case may be, fails to act on the landowner's request within the time limits referred to in paragraph 6, a denial of the request is deemed to have occurred on the 46th day after the close of the last hearing. That was yesterday. Okay? Then the D section, The zoning hearing board or governing body, as the case may be, shall commence its hearings within 60 days after the request is filed, unless the landowners request or consent to an extension, which they failed to do on Sunday. This is all stuff that the judge would need to hear if it goes into the court of law. Then, on the next section, I didn't highlight it, but I'm going to read it. This is the part about legal documents going into press enterprise. The E section in 916. Public notice of the hearing shall include notice that the validity of the ordinance or map is in question and shall give the place where and the time when a copy of the request, including any plans, explanatory material, or proposed amendments may be examined by the public. So that talks about what legal notice is supposed to be presented in the newspaper. It's not 608, okay? So now we'll go down to the next line, the F section. The challenge shall be deemed denied when the zoning hearing board or governing body, as the case may be, fails to commence the hearing within the time limit set forth in section D. That's 60 days, that was Sunday. So it's deemed denied. Then the last section, the section 4, the zoning hearing board and the governing body in the case may be fails to act on the request 45 days after the close of the last hearing. So this is saying that it's up to the supervisor to direct the solicitor to send letters to each of the people on the curative amendment that has been denied for 916 of the county code. That ends the case. Now, when the new ordinance is passed, these same residents come back in with another curative amendment if they don't like how you wrote it. But if you put extra land somewhere as industrial, you did your part. But I wanted to go over this just so everybody had these copies, go over it in detail, discuss it amongst yourselves through the week, and then get with the solicitor what you think should be done. And if you would help them understand what their direction may be or may not be legally. Okay.
I can tell you that.
I can tell you that right now. We're waiting.
Well, I'm not here for, that's up to them to decide and let them direct you, let them understand the code, all right? All right, thank you.
Any other public comment?
Hi there, Eugene with Community Depot Road. I'd like to hear what you were about to say about what's happening next.
What's happening next is we are going to finish with our draft of our amendment to the zoning code. And we are awaiting for the 30-plus township residents to file an appeal with the Court of Common Pleas.
And then the 29th, they started saying, at the beginning of the hearing, the process, if somebody wanted to be an interested party or claim party status, then we didn't hear what the actual process will be. So if this gets appealed, what's going to be the process for directly affected landowners or affected people to be interested parties?
There was an attorney, I forgot his name. Clark. Yes. Who represents, I believe, 4 or 5 people who I believe are opposed to the curative amendment. So he will enter an appearance on behalf of those individuals. Any other interested individuals can enter an appearance as well, once the appeal is filed.
So would people appeal that or submit that to the township or to the court?
To the court.
Okay. All right, thank you.
Is it on or it's still on? I'm not 100% clear on what the sunshine laws are. Is there someone that could explain that to myself and everyone else here, what they are and the importance of them, please?
Are you referring to the comments made by Attorney Karpovich with regard to us allegedly violating the sunshine law?
No, I think I think I'm interested more in how residents can interact with supervisors and those discussions.
Sunshine law requires that public comment be allowed at each advertised meeting. It is required. It is within the purview and discretion of the supervisors as to how long to allot for public comment. Usually it's 3 minutes. I've seen some municipalities allow 5 minutes for public comment. Here it's 3, but we're not holding hard and fast to the 3-minute rule. The township is also within its purview and discretion to restrict public comment to residents or taxpayers.
So do I interpret that as being outside of a meeting like this, that residents should refrain from talking to supervisors, whether individually or more than one supervisor at a time? Any clarity on that?
I didn't say that. It's up to the supervisors as to whether or not to respond to a private conversation, but they're not obligated under the Sunshine Law to speak regarding pending matters, especially in a case like this, which involves litigation.
Okay, thank you.
Sure.
I have a simple request. Can we have handicapped parking spaces for the elderly at some point if we're going to have continuous meetings here? Thank you.
Any other public comment?
Go ahead. I'll wait.
As the solicitor, I'm in charge of declaring the winner.
Go.
Hi, Carmela Matrone, 384 West County Road. And to be honest with you, Attorney Brockman, I was ready to really give it to you. I'm glad that you stood up and you gave us an explanation of what had happened on Sunday. So I do applaud you for that, because I was ready to lay in here. But to go back on what Molly had said here about us gaining status for being close. Now, I understand that you mentioned the ones of us that are represented by our own attorney. However, if this does go to county court, as you can see, we have a lot of concerned residents here. They're not going to make that trip. How do they get standing?
Everyone on the planet, whether it's a civil case or a criminal case, has the right to appear on their own behalf. Pro se, it's called. If you're not familiar with the term, you can appear. You don't have to spend the money to hire an attorney if you don't want to.
No, I understand that. What I'm saying is there's a lot different for all of us to come here that's maybe a 5-10 minute drive. Going to Luzerne County, Wilkes-Barre, we definitely have an elderly population here that's not going to take the trip. Let's face it. Well, how do they gain standing because their properties are but what these people want?
That person will file an entry of appearance. You can do it electronically.
Okay.
On the Luzerne County Pathonetarian's website. You can handwrite it if you want to.
Okay, just because they should have representation as well.
I, Jane Doe, want to enter my appearance pro se. You just put the caption. Once the appeal is filed, there will be an assigned case number. You file it online. Now, when there's a hearing, unless the court orders a public hearing via Zoom, usually you don't have that, especially if there's going to be testimony taken. There's no way around it. You have to attend the hearing at the courthouse.
And there's no way that they could have it kicked back to here and have a mediator come and do it here?
A judge is not going to do that. What a judge might do is allow the hearing to be conducted via Zoom. That's a possibility.
Okay, but just so long as the rest of their people have standing because they're affected.
Anybody who enters an appearance as a property owner in Hollenback will have standing.
Thank you.
Sure.
Can they put that in their request via virtual,
Yeah, you can file it online. Go to the Luzerne County Monetary website, and there's a
But I'm sorry, during their entry, through the Profound Carries website, can they put somewhere in there that they're requesting it be a virtual appearance due to, limitations?
I would suggest that you do it when you file your entry of appearance, because there won't be any hearing scheduled. So when a hearing, and you can also check the status of the case. If you go on search.iqs, okay? That is a service in various states where all of the records are on file on the prothonotary. Luzerne County in Pennsylvania happens to have all of these civil dockets via Search IQS. So you can periodically go to Search IQS, click on Luzerne County, do the search term, whatever the case is going to be called, in re, property owners, curative amendment. I don't know how Donnie Karpovich is going to capture his appeal. But you can search that appeal, that name, and you can see what the status is. And if there's going to be a hearing, you'll see a court order to that effect. Hearing scheduled, such and such a date, and then you can make the request to Zoom. To add it to Zoom.
Sorry, just on that part, when this hearing is scheduled, how do we know?
You would go on Search IQS.
So we have to do it. We're not going to get notified by the township?
Excuse me.
When we get assigned a case number, should we have a public hearing, a public meeting, and go over this with everybody with our special counsel?
Once the appeal was filed, we couldn't go into waiting again as to how to access the case.
Right, I mean, a lot of them, you can say online, but I mean, a lot of people don't have access to do that, or the knowledge to do that. And it just seems to disenfranchise our residents that don't have that ability, but are here and want to be heard. And now if this is, we need to know when the hearing is, so that they can now file what they need to file to protect themselves.
We can make that announcement.
Thank you.
Sure.
Corey Wetzel, Bell Road. I think I speak for most people here when I say that during the last 2 months, we've all experienced a range of emotions and feelings because of the events that are taking place here in the township. Friends and neighbors find themselves on opposite sides of an issue that is dividing the entire township. But the emotion that I'm kind of stuck on and still trying to rectify is disappointment. Disappointment in our township government, disappointment in the sloppy way that it appears that some of the things were handled by the supervisors and by the people that the supervisors employ. In reviewing the proposed zoning ordinance, I found references to fire plans having to be approved by the Wilkes-Barre City Fire Chief. While I have the utmost respect for Chief Delaney, he doesn't have any authority here. The ordinance was prepared by the solicitor and had been already reviewed by the supervisors, the planning commission, and the county's planning commission at the time that I saw it. And that means that all three of those groups also overlooked or didn't pay attention to the things that were written in the ordinance. At the curative amendment hearing, the solicitor wasn't able to provide a copy of the advertisements for the meeting. It was a quasi-judicial hearing. That's the time to bring evidence, and the evidence wasn't brought to be able to be produced if there was a question about whether it was published or not published. I'm not an attorney, but I've spent almost 35 years reading, interpreting, and applying Pennsylvania statutes and codes and testifying in court. I've read the applicable sections of the Municipal Planning Code. The Municipal Planning Code requires that notice of said public hearing shall be conspicuously posted by the municipality along the tract of land at least 1 week prior to the meeting. It also says that notice of the public hearing shall be mailed by the municipality by first-class mail at least 30 days prior to the hearing to all of the involved parties. In legal matters, the word shall is not optional. Shall means it must happen. Not, if it was optional, they would use the word may. Henry Clay said that government is trust and that the officers are trustees. I can't help but feel that our trustees have let us down in this instance. I hope that we will see some kind of accountability for these failures, and I can assure you that we, the people, will be here watching and hoping for better moving forward.
Anyone else for public comment? Hearing no further public comment, turn it back over to the speaker.
I make a motion to adjourn the meeting